Harry here to talk about the fallout in the prosecution of the January 6 defendants of the Supreme Court's recent opinion in the Fisher obstruction case. This is not Donald Trump and his case, and I'm going to get to that shortly. In fact, it's not point one here. It's not most defendants. As Merrick Garland said just a few days after Fisher came down, the vast majority of defendants will be unaffected. And of that minority, most of them will still be subject to roughly the same penalties. So this isn't a real body blow to the overall prosecution, which is the largest in DOJ history of all the January 6th marauders. That's point one. Okay, point two, who is actually getting a break here, or who is getting the direct benefit of the Supreme Court's opinion? So recall Fisher himself. He had several charges, and he challenged the obstruction charge in particular, and which came under a actual provision of Sarbanes-Oxley, the big statute passed to deal with all the sort of financial crises of the aughts. And the basic theory that the Supreme Court accepted over a dissent, by the way, by Justice Amy Coney Barrett, joined by two liberals, but they basically said, look, and there's a whole tussle about the word otherwise, but the basic notion is you need to be found guilty of this crime to actually try to mess with evidence. The classic would be, hide or destroy or shred evidence. Fisher himself seems to have been a guy who was just nasty, along for the ride, like the big party, but couldn't tie him to anything related to the evidence, even the attempt to suppress the January 6th hearing itself. And this brings to the point number three, and Trump and that of most defendants here. The DOJ has telegraphed that they're going to take a narrow interpretation of the holding in Fisher, and including in the few cases where they've nodded to it. And basically, I think the theory will be that if in one way or another you're marauding and troublemaking affects actual evidence, including witness testimony in the case, then you should still be guilty under this statute as narrowed by the Supreme Court. Most importantly, say for Donald Trump, and this showed up actually an oral argument with questions by Justice Jackson. What's he trying to do on January 6th? He's trying to suppress the bona fide January 6th certificates from the various states and replace them with phony certificate. That the DOJ is going to be saying down the line. It totally fits the Supreme Court opinion as reconfigured, and they're still going to go for that. And likewise for people who can be shown to have proof of wanting to really suppress the hearing, get at Mike Pence, all the sort of thrust of things we knew. But the kind of along for the ride is a little bit of a tame way to put it. But even folks who have some notoriety because they've shown up in the pictures, if they can just argue, we just stumbled in and we're there for the party, then obstruction, they may not be subject to it. Good example is someone whose charge was, in fact, the department withdrew, Arthur Jackman. He's a, definite Proud Boy, and he's photographed in close proximity with the leaders of the group. He's convicted of seditious conspiracy eventually for how things develop, but he doesn't seem to have either trespassed or engaged in disorderly conduct. He's on the periphery looking out, and for that reason they drop that charge. That's a sort of unusual one. And then there's another defendant, Kelly Sorrell, who's the girlfriend of Stuart Rhodes, and a couple of her charges were obstruction. They're going to offer a plea bargain dropping the obstruction. Okay, so there are a handful of defendants so far. There have been others whose sentencing have been kicked down the road, and one other who they dropped the charge mainly so they wouldn't have to delay the trial. So those all matter, but the basic thing to know about Fisher is that the DOJ is determined to interpret it narrowly, and as long as there's some effort to suppress testimony, mess with any evidence, etc., they're going to go pedal to the metal on it, and then that would certainly indicate Donald Trump if and when, of course, that case ever goes to trial. And who's left are, a handful or more of that. We're talking some 1,000 defendants in the case, and almost all of them have ample other charges, so it's not really a bottom line. No January 6th marauder is getting a big break or taking a walk as a result of the Fisher opinion. But the DOJ is hewing to this narrow line, and it's, of course, possible that judges, the Jackman case, say, is in front of Carl Nichols, a Trump-appointed judge, who nevertheless seems to have been pretty reasonable, but you'll certainly have defendants saying they're interpreting Fisher too narrowly. I didn't, really try to do anything that fits that description, etc. And you could have a district court. You may have this go up again to the D.C. Circuit and even the Supreme Court. They seem to have a big appetite for all this stuff. Nevertheless, for now, what we're talking about is a very narrow impact on a very small band of potential and of actual defendants, a few of whom are going to have the obstruction counts dismissed. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.